We are asked all the time about whether restrictive covenants are enforceable in New York. The very short answer is that restrictive covenants are enforceable in New York. While restrictive covenants are enforceable, they need to be reasonable and they need to be narrowly tailored based on the specific circumstances of the physician and that physician's practice.
The technical answer to the question is yes. Restrictive covenants are enforceable, but there are significant limitations placed upon the scope of the restrictive covenant, and there are a number of defenses that are available, such as if the employer breached the contract or if the employer terminated the contract under circumstances where courts have recognized that a restrictive covenant would not be applicable. As a result of the consolidation of physician providers into health systems, there are also some very novel and interesting questions being raised concerning a hospital's ability to enforce restrictive covenants with respect to other health systems in the state, which cases I'm sure will be brewing through the court system of the upcoming years.
The courts in New York State typically do not like restrictive covenants against physicians in the state of New York. The reason for that is they really don't feel comfortable restricting physicians from practicing medicine. However, case law does show that to the extent that the non-compete or the restrictive covenant is deemed to be reasonable, they will in fact enforce it. So then the question becomes, what's reasonable in the state of New York?